Ms. Sun Xueling.
Mr. Speaker, I thank members for the robust debate, the pertinent issues raised, and their support for the bill. Important issues have been raised by members regarding the proposals and regarding the very institution of marriage and family in Singapore. Let me first reiterate our core beliefs regarding marriage and divorce, which our proposed amendments intend to strengthen. Marriage is the cornerstone of family formation in our society. We must protect the institution of marriage by ensuring the significance of the solemnization and registration of marriages and that marriages contracted here are genuine. Divorce must be a last resort. Our first priority is to save marriages where possible. Where there is no alternative but divorce, our aim is to help families heal and move on. Reducing acrimony and promoting child centricity in divorce is key. The Women's Charter is a significant act, enacted in 1961. Ms. Carrie Tan and Mr. Louis Ng proposed renaming the Women's Charter to the Family Charter. We will not be doing so in today's amendments, as if we look at the provisions on marriage and divorce, the provisions are gender neutral and do not discriminate in favor of men or women. The Women's Charter sets out how family and family relationships should be managed. To quote Professor Leong Wai Kam, School of Law, SUSS, the Women's Charter promulgated the idea of marriage as an equal cooperative partnership of different efforts. The Women's Charter also provides for protection of women and girls in the areas of vice, prostitution activities, for which there is good reason for this distinction, as women are disproportionately affected. And while Singaporean women today are better educated with better employment opportunities, there are still vulnerable women who require the protection of the Women's Charter. Now, moving on to the issues regarding the marriage-related proposals, in reviewing the marriage processes under the Women's Charter, we sought to achieve two key things. Firstly, we sought to enhance the marriage process to provide greater convenience to couples. The amendments will enable us to take the marriage process online via the Our Marriage Journey portal later this year. Mr. Gan Thiam Poh raised concerns of marriages of convenience, and I assure members that the Registry of Marriages will continue to perform due diligence. If there are concerns, the declaration will be performed in person or via video link instead of online, and the registrar may decide not to permit solemnization via video link. Mr. Gan Thiam Poh asked how many marriages of convenience we have seen and how many have been involved in vice activities. Between 2014 and 2021, there have been 388 individuals convicted for engaging in or arranging such marriages. We do not track if they have engaged in vice activities. Ms. Joan Pereira asked if digital certificates will apply to both civil and religious ceremonies, and who would issue the digital certificates. Digital certificates will apply to all solemnizations and will be issued by the Registrar of Marriages. Ms. Ng Ling Ling voiced concerns that digitalizing the solemnization may downplay its significance. We understand her concerns. Hence, couples may choose to hold their solemnization in person. Indeed, we have seen that most couples still prefer to hold their solemnizations in person. In addition, while a digital marriage certificate will be issued, a hard copy ceremonial marriage certificate will also be provided as a keepsake. Through the Our Marriage Journey portal, we will continue to emphasize the importance of the solemnization. Second, we sought to update the necessary safeguards to ensure that the institution of marriage is not abused and continues to be protected. Beyond legislative amendments, upcoming initiatives also boost our efforts to strengthen marriages and families. We have brought together stakeholders, community partners, and Singaporeans to co-create and implement solutions through the launch of the Alliance for Action to Strengthen Marriages and Family Relationships last year. We have also woven support for couples into the marriage process. Mr. Melvin Yong suggested more can be done to encourage couples to attend marriage preparation courses, including by making it mandatory. The Our Marriage Journey portal will recommend and encourage couples to sign up for such courses. However, it is only mandatory where one party is below the age of 21, as the dissolution rates for such marriages are relatively higher. Nonetheless, we strongly encourage all couples to attend marriage preparation programs, and we provide rebates of $140 for couples to attend the 12-hour prep workshop or $70 for supported programs offered by the community. I also agree with Ms. Joan Pereira that it is important that solemnizers are equipped with counselling skills. We have started a pilot initiative, Journey with You, in short referred to as JOY, J-O-Y, which enables licensed solemnizers to mentor newlyweds in the first year of marriage. They will undergo training and are provided referral resources. Let me move on now to the issues raised on the divorce proposals. I'm glad that there is consensus between members on several areas. First, as raised by many members, divorce is and must be a last resort. Where possible, we aim to save the marriage and help couples resolve their issues. I agree with Mr. Ip Hong Wing that couples should be encouraged to seek counselling early before marital issues worsen. Where there is no other option apart from divorce, we aim to help couples heal, and we also ensure that the welfare of the children is protected. Mr. Melvin Yong brought up the worrying trend of more recent cohorts divorcing earlier. He asked why such a trend has emerged. We believe that this is due in part to higher expectations of marital satisfaction and greater stressors in the early years of marriage, especially as more couples are dual income and they juggle career and parenthood. This is a trend not just emerging in Singapore, but it has been apparent in many parts of the world for some time. Therefore, as raised by Mr. Lim Biao Chuan, Mr. Ip Hong Wing, Mr. Melvin Yong, and Mr. Julkarnain Abdul Rahim, our commitment is to protect the marriage and save it where possible. But we must do more beyond legislation. The legislative amendments must be seen in totality with non-legislative initiatives which will help couples resolve issues at all stages of their relationship. When stresses begin to emerge, we have marital and family counselling under FAM at FSC to help families resolve issues early. Mr. Melvin Yong suggested that marriage therapy be made more accessible and affordable. Mr. Ip Hong Wing also asked if there are sufficient trained professionals to cater to demand, and what the average waiting time is for appointments, and if there is remedial action if the couple does not attend subsequent counselling sessions. Ms. Mariam Jaffar similarly asked about funding and resources for such services. I'd like to say that by the end of this year, there will be 10 FAM at FSCs across the island that can support couples facing marital and familial stress, and they will be well equipped to manage the projected demand. In terms of the waiting time, parties will be contacted by the agency within a week. As these counselling sessions are voluntary, there is no remedial action that can be taken by the ministry or the FAM at FSC should the couple not choose to continue. Nonetheless, if counselling were ordered by the court, then in the case of non-compliance, the court may make any further orders as it deems fit, including staying proceedings until parties have attended counselling. If couples are not able to resolve their issues and are contemplating divorce, we are also working on a family assist portal which will provide couples with links to marital counselling and allow reflection and also information so that couples can make an informed decision. Finally, should couples choose to proceed with divorce, within the divorce process, couples are given opportunities to resolve their issues and to U-turn on their decision. Mr. Ip Hong Wing had asked if the ministry would consider mandating pre-divorce counselling for couples, citing DMA. Ms. Mariam Jaafar raised similar points on requiring divorcing couples to take parenting education courses and making counselling mandatory. With the amendments, all divorcing couples with minor children must attend MPP before filing for divorce. At MPP, counsellors may assess the couple's suitability for reconciliation and refer them for further support. Mr. Melvin Yong asked if this pre-divorce counselling could be extended to those who cite unreasonable behaviour. We agree that it is good to do so, but our priority at this point is to extend MPP to all divorcing couples with minor children, regardless of the fact that they cite. We will explore extending pre-divorce counselling further at a later stage. I also fully agree with Ms. Shahira Abdullah that religious organisations can play an important role in mediation and counselling. And couples may choose, and parties may choose to opt for counselling by religious organisations if they are of the same faith. I would like to thank Mr. Zulkarnain Abdul Rahim for sharing the Sharia Court's experience with implementing the marriage counselling programme. Indeed, it is through learning from the Sharia Court's positive experience that we have decided to introduce pre-divorce counselling. Members also agree that it is key that families are supported throughout the divorce process. On the programme for children, Ms. Joan Pereira raised the importance to support all children, including the older ones. We fully agree. And as part of the MPP, the counsellor would encourage parents to sign their children up for suitable programs. To Mr. Louis Ng and Mr. Zulkarnain Abdul Rahim's queries on why the programme for children is not mandatory, what the types of intervention under the programme for children are, and whether there can be a national body to harmonise programmes for all children affected by Muslim and civil divorce, I would first like to assure members, such as Ms. Shahira Abdullah, who also brought up the need for Muslim marriages to be supported, that MSF and MCCY work closely together to ensure that the programs offered to all children affected by divorce are similar. In addition, the program for children is also available to children affected by Muslim divorce. There is therefore no need for a separate body to oversee this. The program for children covers various component items. It includes an assessment of the needs of the child, counselling, psychological services, as well as specific evidence-based programs such as Children in Between. MSF had considered mandating all minor children whose parents are undergoing divorce to attend a program to help them cope better with the divorce. However, we believe that parents, even as they undergo divorce, must still assume primary responsibility for their children's well-being, rather than have the government mandate a program for their children. We are also mindful that mandating counselling for all children may also cause additional stress, and that not all children may be ready for the program. Lastly, on the issue of child access enforcement, I agree with Mr. Lim Biao Chuan and Mr. Zulkarnain Abdul Rahim that children should not be used as a negotiating tool in their parents' quarrels, and those who breach access orders must face consequences. Both members also brought up the need for enforcement orders to be made judiciously, especially in the case of a term of imprisonment. I assure members that the court will take all aspects of the case into account in making its orders, including whether the child had refused access to the parent and a term of imprisonment is intended to be imposed only on egregious cases of non-compliance. The court may reverse the grant of care and control to the access parent if it is in the best interest of the child to do so. On orders to make up access, as with all orders related to the child, the court will make this order taking into consideration the best interests of the child. For parties with counselling orders, FEM at FSCs and DSSAs will work closely with the courts to support them in issues faced with access. The 10 FEM at FSCs set up by the end of this year will be able to manage the expected caseload. However, we have also heard different views raised by members. particularly on whether we should make the divorce process more expeditious, or whether doing so could lead to easier divorces and erode the institution of marriage. I fully agree with Ms. Sylvia Lim, Mr. Lim Biao Chuan, and Mr. Melvin Yong that a balance must be struck between making it too difficult for couples to divorce and making it too easy to give up their commitment. Beyond non-legislative efforts to strengthen the family and upstream measures to help families facing stress, we also want to ensure that the divorce process affords parties opportunities to save their marriage and U-turn on their decision, and the divorce process, even with the introduction of DMA, is not made easier nor faster. For this reason, the safeguards to ensure the decision to divorce, that it is a considered one, remains. This includes, number one, the 3-year minimum marriage period before divorce can be filed. Number two, minimum 3-month period before divorce is finalized. And number three, that the existing 5 facts for parties remain for parties who prefer to rely on them. The divorce process also remains largely the same no matter which fact is cited, including DMA. In fact, citing DMA requires further submissions to the court. A, the reasons leading parties to conclude that their marriage has irretrievably broken down. B, the efforts made by parties to reconcile. And C, considerations given to the arrangements to be made in relation to the parties' children and financial affairs. It is also for this reason that we will not be reducing the 3-year minimum marriage period before a divorce can be filed, as Ms. Carrie Tan has suggested. The 3-year minimum period is an important safeguard to ensure that couples do not enter or exit a marriage lightly. The first year of marriage is often not an easy one, given the many transitions and adjustments for couples. The 3-year minimum period will thus allow couples sufficient time to adjust, seek help, overcome difficulties, rather than just leave the marriage just because things are difficult. If they truly wish to pursue divorce, the 3-year minimum period will also allow them sufficient time to consider their decision carefully and also make attempts at reconciliation. Nonetheless, where there are legitimate reasons where a party may need to exit the marriage before the 3-year minimum period is up, the Women's Charter allows for that. In cases of exceptional hardship or depravity, parties may seek the court's permission to file for divorce before the 3-year minimum marriage period is up. However, where parties have made and failed at every effort to save their marriage and have no other option left but divorce, then there is a need and a place for DMA in cases where parties agree on the divorce to reduce acrimony. Mr. Lim Biao Chuan asked why DMA is needed when the separation fact allows couples to divorce without apportioning fault. Divorcees who have filed for divorce on the simplified divorce tract have shared with us in our engagements that though they had agreed on the divorce and ancillary matters, having to cite a fault-based fact did dredge up pain and the hurt deepened when parties read the affidavits from each other. They expressed how they wanted instead to be able to take joint responsibility for the marital breakdown instead of citing fault. They also told us that they found it difficult to rely on the separation fact, as they felt that their lives were put on hold during the separation period and they could not move on. And this was not good for their well-being. It was also not good for their children's well-being because, try as they might, they admitted they could not focus on their children until the divorce was finalized. In the meantime, the children were exposed to the tensions in their relationship during the separation. DMA therefore allows such couples to jointly take responsibility for the breakdown of the marriage and heal and to move on from the divorce. Mr. Lim Biao-chuan raised concerns as to whether DMA would effectively reduce acrimony, given parties must submit the reasons, leading them to conclude that marriage has irretrievably broken down and they may disagree on matters concerning their children and finances. It is inevitable that in certain cases, even with DMA, the couple will still face acrimony in the divorce process. However, providing the option for parties to jointly take responsibility rather than pinning the blame solely on one party would more likely set the frame and mindset for a less acrimonious and conflictual process. Thereafter, when parties proceed to the ancillary discussion, they are more likely to do so without the resentment of either having to bear full blame for the divorce or the pain of having to dredge up past hurts. Having jointly taken responsibility for the breakdown of the marriage, they can begin ancillary discussions more amicably. I would like to emphasize again and assure Mr. Lim Biao-chuan, Mr. Ang Wei Neng, Mr. Melvin Yong, and Mr. Ip Hong Wing that DMA differs from the no-fault divorce that we see in other jurisdictions. Unlike other overseas regimes where parties are not required to prove that the marriage has irretrievably broken down, or where the filing for divorce by one party is sufficient to prove the marriage has irretrievably broken down, DMA is a sixth fact to prove the sole ground of divorce, and it is done through an agreement that cites, number one, reasons for the breakdown, number two, efforts at reconciliation, and number three, considerations for children and financial matters. One party cannot unilaterally divorce the other. Some jurisdictions have removed the ability for a party to contest the proceedings. Under the Women's Charter, the defendant is able to file a defense against a divorce application, irrespective of the fact cited. I would also like to assure Ms. Sylvia Lim that we do not expect the number of divorces to increase significantly with the introduction of DMA. Spikes or long-term increase in divorce rates occur when a regime switches from fault-based to non-fault-based. We had made this transition in 1980 from a purely fault-based regime to a hybrid regime with no fault grounds, and we had introduced a simplified divorce track in 2015. We saw no significant increase in divorce then. Members also raised queries on the divorce-related proposals. Regarding the details of DMA, Ms. Henny So asked what reasons are acceptable to substantiate that the marriage has irretrievably broken down. This could include reasons such as a deep-seated difference in values, and the intention is to avoid reasons that point blame only at one party. And children should not be cited as the reason for divorce. In fact, as Ms. Shahira Abdullah has pointed out, one of the aims of DMA is to spare children the pain of having their parents make, prove, and disprove allegations against one another's misdeeds, so children are better able to cope with the divorce. Ms. Ong Ling Ling asked how the court will assess if a marriage is still reconcilable and whether MSF would be able to make recommendations to the court. Mr. Ip Hong Wing similarly asked if the assessment would involve professionals in family matters. Ms. Sylvia Lim expressed concerns about whether parties would lower the threshold for divorce as to whether DMA would lower the threshold for divorce compared to the other 5 facts. Ultimately, the legal test for the granting of the divorce is the irretrievable breakdown of the marriage. There are currently 5 facts with their own respective requirements. DMA is a broad ground, but parties will still have to meet the threshold of irretrievable breakdown of marriage. If parties cite evidence relating to one of the 5 established facts, but do not quite meet the prescribed requirements, it remains open to the court to grant the divorce on the grounds of DMA. But before doing so, the court will have to assess the facts carefully, bearing in mind that a divorce cannot be granted under DMA if there is reasonable possibility of reconciliation. The court will have to carefully consider whether or not to depart from the requirements of one of the 5 established facts, taking into account the specific circumstances of the case. DMA is a different fact on which you can obtain a divorce, but it is not an easier fact. The court will have to assess the agreement based on the matters set out in the statement of particulars submitted by parties to the court, which contain the 3 requirements needed by DMA, and make an assessment that the efforts detailed suffice to satisfy a party-centric test that parties have made best efforts and have done all things necessary to attempt reconciliation. This is not present in the current 5 facts, including forced separation with or without consent. All this represents a paradigm shift that is different from, but not necessarily easier than the current 5 facts. Over time, the courts will develop case law on DMA. In all cases, parties have to meet the 3-year time bar before they can apply for divorce. A party who relies on DMA will thus not necessarily be able to obtain a divorce sooner than a party who relies on adultery, desertion, or unreasonable behavior. It all depends on the facts. For couples with minor children, they will have to attend MPP at the DSSA or FAM at FSC before filing for divorce or filing a counterclaim when served with divorce papers. We will enhance the MPP to encourage couples to consider reconciliation if possible. For couples who are open to reconciliation, a counsellor can help to support them through this process, and otherwise the couple may proceed to divorce should they wish to do so. At the point of filing, should the court assess that reconciliation is still a reasonable possibility, the court may refer the couple for counselling at the DSSA or FAM at FSC. After counselling, parties may continue with the divorce process should they choose to do so. Ms. Joan Pereira similarly raised concerns on the submission of efforts to reconcile to the court. In particular, Ms. Joan Pereira was concerned that this would add tension to an already strained relationship. The premise of DMA is to allow divorcing couples to come together and help a broken relationship without further strain. We expect that couples who cite DMA would have discussed their issues and how to resolve the dissolution of the marriage in an amicable manner. It is for this reason that the fact is founded on mutual agreement. If there is no consensus on all matters, it is highly unlikely that the couple would opt for this fact. The application therefore gives the couple space to discuss, communicate, and resolve all issues, including reconciliation efforts, before presenting this application by mutual agreement to the court. To Ms. Henny So's query on whether DMA may only be cited on the simplified track, and if divorce is filed, citing another fact can later be allowed to proceed on an amended claim under DMA, we envisage that most parties who cite DMA would file on the simplified track. However, DMA is not limited only to the simplified track, and those on the standard track may choose to cite DMA as well. As for whether parties who originally cited another fact can later be allowed to amend their claim and cite DMA, parties can apply for leave to amend the claim subject to fulfilling the requirements of the family justice rules. Ms. Mariam Jaafar asked about a minimum time period for the proceedings to allow for reflection. Mr. Ip Hong Wing also asked how long the process would take from the time divorce is filed and if the couple can appeal the court's decision. The average duration taken depends on the track that the divorce application proceeds on. For couples who contest the divorce or ancillary matters, the duration varies and could take some time. For couples who divorce on the simplified track, the time taken from filing to the grant of the interim judgment is approximately 6 to 12 weeks. Thereafter, there would be another minimum of 3 months to the final judgment. We envisage that couples who cite DMA would likely file for divorce on the simplified track but citing DMA instead of the existing 5 facts. And that would not change the duration in any way. As for appeals, as this is a consent application, it is unlikely that there should be an appeal, and should one party change their mind, they can apply to set aside the grant of the interim judgment. Regarding Ms. Mariam Jaffar's suggestion for a minimum period after the divorce is finalized for counsellors to check in on couples to ensure that they are coping well, any family that has issues with the divorce or its impact can seek post-divorce support at the FAM at FSC and the DSSA. Ms. Ng Ling Ling asked how the court will ensure that the agreement under DMA is entered out of the parties' own volition. Ms. Sylvia Lim also asked if the court will act as a watchdog in cases of vulnerable spouses who may be coerced into agreeing to a divorce under DMA and to unfavourable terms under the divorce relating to their children and financial affairs. As I have said earlier, we rely on family lawyers to prevent such cases. In addition, the Mandatory Parenting Program, or MPP, which I've been referring to, it is a mandatory pre-filing program for parents, and this can act as a safeguard against such instances as the counsellor may identify and assist such spouses. Indeed, for an agreement to be made under DMA, the court must, amongst other things, assess that parties are acting voluntarily and have the requisite knowledge of the terms. Members also raised queries on other aspects of the divorce process. Mr. Melvin Yong asked about the penalties that may be imposed on parties should they be found to have divorced for financial benefits, such as to own multiple properties without additional buyer's stamp duties. I assure members again that DMA does not make it easier for parties to get a divorce. In fact, parties who choose to go on DMA have to satisfy the court that there is no reasonable possibility of reconciliation. Lawyers must also do their part to ensure that divorces are genuine and their clients are not intending to enter into a divorce just in name. Ms. Ng Ling Ling asked where one party refuses to attend MPP, whether the other party would be hindered from proceedings with the divorce, such as in cases of family violence where the perpetrator may be unwilling to attend. In a case where one party refuses to attend MPP, the other party will still be able to proceed with the filing of the divorce after they have themselves completed MPP. As for the perpetrator, he or she must attend the MPP if he or she wishes to file a counterclaim to put forth his or her points relating to the divorce and ancillary matters to the court. The DSSA and FAM at FSCs will also provide or refer parties for support if they disclose experiences with family violence. Regarding the issue of child access enforcement, I would like to assure Ms. Hanny So that should parties be ordered to take part in therapeutic programs or counselling at the DSSAs or FAM at FSCs, that they will not incur any fees. As to increasing the number of complementary sessions for parties to carry out supervised access at the DSSAs, there are no plans to do so, as the intention is to foster a sense of responsibility in parents in managing their own relationship to co-parent effectively by requiring them to contribute a sum for supervised access. Supervised exchange and supervised visitation is intended as an interim measure to help parents work towards independent access. I would also like to assure members that should any parent face issues of access to their children, they are able to seek help at the FAM at FSCs and DSSAs. As Ms. Mariam Jaffar has raised, there is no difference in services offered to men and women. As to increased legal assistance to parents, the means test is reviewed at regular intervals, every 5 years or so, with the last amendment to the means test being done in 2019. The Ministry of Law will continue to review the means test regularly in order to ensure that less privileged persons who need legal help continue to get it. The Legal Aid Bureau also has a merits test in order to ensure that legal aid is not given for frivolous, unmeritorious claims. Thus, it is not just about ensuring that those who need it get legal help for access matters, but that the manner in which they conduct the case and the merits of their position in the case are reasonable. For access matters, court litigation should very much be the last resort. Mr. Zulkarnain Abdul Rahim and Mr. Lim Biao Chuan also raised concerns regarding the provision to allow the court to direct the bailiff to restore a child to the physical custody of a person in whose custody or care and control the child is placed. The courts will only order the bailiff's assistance in cases where their presence is absolutely necessary, and not in all cases. To safeguard the child's well-being, the bailiff will be accompanied by the applicant, usually the other parent. Where required, the bailiff is also empowered to activate auxiliary police officers for support. It is pertinent to note that the same powers exist in the Guardianship of Infants Act and is available to all parents and guardians of a child. This proposal seeks to extend the same relief to parents who have divorce, nullity, or judicial separation proceedings. On the issue of maintenance enforcement, Ms. Sylvia Lim and Mr. Ang Wei Neng noted that the current maintenance enforcement process can be further enhanced. As I have said so earlier, the MSF is working with the Ministry of Law and the Family Justice Courts to study how to provide more efficient and effective enforcement of maintenance orders and to minimize repeat enforcement. We are considering the feasibility of taking up these amendments under a separate legislation. Ms. Carrie Tan and Mr. Ang Wei Neng also raised the issue of allowing maintenance applications to be made for husbands without the condition of incapacity. We have considered this. However, while women are in a much better position today than they were many years ago, we recognize that even today, in a marriage, it is more likely for a wife to give up her career to care for her family while her husband continues working. And this means that post-divorce, women tend to be financially more vulnerable. The current provision therefore provides maintenance for the parties that tend to be more financially vulnerable post-divorce, women and incapacitated men. While we want to move towards gender neutrality, those who are more vulnerable must be protected. In any case, the courts refrain from granting high amounts of maintenance to wives who are able to work, even if they had not worked or stopped working for some time. The court's goal is to award reasonable maintenance that will meet the financial needs of the wife until she can secure for herself some form of employment and adjust to her post-divorce situation. The issue of parental alienation was also brought up by Ms. Mariam Jaffar. We do not think that there is a need to define the term parental alienation in order to ensure that those who are impacted by it are supported. Rather, parents who believe that they are victims of parental alienation are encouraged to seek help for themselves and their children at FSCs or DSSAs. And if such methods fail, parents may consider legal recourse.
Leader.
Mr. Speaker, as MOS time limit for her speech is approaching its end, may I make the following? May I move for the following? May I seek your consent and the general assent of members present to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order Number 48H to remove the time limit in respect of MOS Sun Xueling's speech.
I give my consent as the Leader of the House of the general assent of honourable members present to so move. Aye. Leader, please proceed.
Mr. Speaker, I beg to move that the proceedings on the item under discussion be exempted from the provisions of Standing Order Number 48H in respect of MOS Sun Xueling's speech.
The question is, as moved by the Leader of the House, as many as of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Ms. Sun.
We also recognize that there may be those impacted by divorce that require even more support, given the challenges of caregiving. Ms. Yeo Wan Ling, Mr. Melvin Yong, and Mr. Seah Kian Peng brought up the issue of support for mothers who may be unemployed during the divorce. With the proposed amendments, all parents with minor children must attend MPP before they file for divorce. The MPP covers several areas, including co-parenting and the impact of divorce on parties' financial status and living arrangements. If employment support or financial support is needed, the MPP counsellor would refer the parties for employment or financial assistance. Ms. Yeo Wan Ling and Mr. Seah Kian Peng also asked about support for parents with caregiving responsibilities, including greater flexible work support and other policies for better work-life harmony. The MOM introduced the Tripartite Advisory on Flexible Work Arrangements, or FWAs, and Tripartite Standard on FWAs in 2017, and subsequently the Tripartite Standard on Work-Life Harmony in 2021, which guides employers on how to offer FWAs to their employees and provides recognition to employers who do so. The MOM will continue to work with tripartite partners to strengthen the provision of FWAs and other work-life practices. In August 2021, the MSF also set up an alliance for action to strengthen marriages and family relationships. One of the focal areas is on support for single parents, which aims to enable single parents to better care for their children and raise their families through strengthening the ecosystem of support around them. The Alliance for Action will work with community partners to strengthen support for single parents. And this includes childcare, employment and socio-emotional support, facilitating support networks for single parents, and developing a one-stop portal to help single parents access programs and community resources more easily. Mr. Louis Ng brought up the issue of access to HDB flats for divorcees with shared care and control of their children and made several suggestions. I thank him for those suggestions. Under current HDB policy, all individuals are only allowed to be listed in one HDB flat application. At the same time, divorcees with shared care and control of children have an equal right to list their children in their flat application. The HDB is not in a position to determine which parent can exercise the right to do so, and thus requires divorced parents to try to come to an agreement in the first instance before listing their child in a flat application. I agree with Mr. Ang Wei Neng that we must support those who face difficulties. For those who are unable to reach an agreement with their ex-spouse or have low income or have no other housing options, the HDB can exercise flexibility to waive the requirement on a case-by-case basis to ensure that both parties have options to provide housing for themselves and their children. For cases where the ex-spouse has bought a private property after the divorce, they may still wish to list the child in a future flat application. As such, the HDB will review each case individually and will not be able to waive the mutual agreement requirement as a blanket policy. The HDB does not require the court order to state which parent is allowed to list the child as an essential occupier, as orders pertaining to a child are made with the overarching principle of the child's best interests. When determining issues pertaining to a child's welfare, the court order focuses on rebuilding relationships and for parents to focus on the future with their children, instead of specific orders laying down conditions such as the one referred to. As far as possible, we want to encourage divorced parents to work through issues cooperatively and harmoniously outside of the court system. This is especially pertinent in cases where there is shared care and control, as it is not ideal for parents with shared care and control to seek or rely on court orders to lay down all matters and details pertaining to care of their children and arrangements after divorce. Instead, they should be working on co-parenting cooperatively in the child's best interests. Those awarded share and control must also, when they applied for it, truly be able to divide the care and control of the child equally and be able to cooperate to do so. Nonetheless, we recognize that there may be cases where parents are unable to reach an agreement despite their best efforts, and in such cases, they can approach the HDB to discuss their options. As Ms. Mariam Jaafar had raised, the area of family law is an important one that often most impacts people and their families. It is for this reason that our proposed amendments seek to strengthen the therapeutic justice to strengthen therapeutic justice in the family justice system, and we're working with FJC to include monitoring standards, processes, and complaints. Nonetheless, the various professionals involved in the process are subject to their respective codes of practice. If passed in Parliament, we expect all the marriage-related amendments and some of the divorce-related amendments to come into effect in the later half of this year, while others, such as DMA, would come into effect in 2023, to allow time for the courts, lawyers, social service agencies, and other parties to be ready. In conclusion, our families are key building blocks of society, and we must do what we can to ensure that they are protected and strengthened. I believe that viewed holistically, these proposed amendments to the Women's Charter relating to marriage and divorce will strengthen the institution of marriage and support families should they have to pursue divorce as a last resort. I thank everyone who has provided feedback during our engagements and who had made the proposals presented here today possible. Beyond legislation, it is truly the efforts of the community that make a difference to those impacted by a divorce. I also urge experienced couples to do their part to actively mentor and counsel younger couples in their social circles or religious organizations, fostering the efforts of licensed solemnizers under the Joy Initiative. I also encourage passionate individuals and ground-up groups to partner the MSF's Alliance for Action to organize family activities, programs to strengthen marriages and family relationships. I'm also excited to be working with Families for Life, a ground-up movement to build strong and resilient families in Singapore. However, we also recognize that more can be done to enhance protection against violence, and we will be proposing amendments in a separate bill by the end of this year to implement the recommendations from the Task Force on Family Violence. With that, I thank members for your valuable input and support for this bill. Mr. Speaker, sir, I beg to move.
Are there any clarifications? The question is that the bill be now read a second time.
Mr.
Many
Speaker.
of the
Mr. Speaker.
Sorry. Silim Belchuan, sorry.
Thank you, Mr. Speaker. I want to thank the Minister of State for her clarification. He has given me much assurance of the government's commitment to the institution of marriage. Perhaps I can, if I may clarify, if the divorce by mutual agreement is not accepted by the court, the Minister of State has said that the court can direct parties for counselling. However, my understanding is that counselling requires parties to agree, and if the couple refuses to attend counselling, what does that mean for the court's directions? Would it be mandatory? Would it be compulsory? Or does it mean that the parties would then have to file for divorce based on the other grounds under Section 95A of the Act? My experience is that most couples, by the time they come to see a lawyer, are unwilling to consider counselling. And it gives them great pain to have to revisit their decision, and much less if the court has to redirect them to go for counselling. Thank you.
I thank the member for his clarification. If the court had directed the parties to go for counselling, it would have meant that in their application for DMA, that they had not satisfied the requirements under the DMA. As such, if the parties would still want to continue with their divorce applications, then they will have to cite a different fact. Thank you.
Ms. Heniso?
Thank you, Mr. Speaker. I have one quick clarification in relation to the mandatory parenting program. I understand from MOS that it will be made compulsory for all divorcing parents with minor children. Can I check whether this plan is also intending to extend to those where the children has already attained age of 21, but actually suffers from mental or physical disability. Because currently, when you file a proposed parenting plan, it actually applies to those parents with this kind of family settings.
I thank the member for her clarification. Indeed, for children who still require, who will benefit from having their parents go for MPP, and if they have exceeded the age limit of 21, the parents can similarly do so. Thank you.
Ms. Mariam Jaffa.
Wes, for your clarifications. And many of them address some of my concerns. I think I still have a lingering concern on the area of enforcement of access and parental alienation, because the lived experience of my residents is that the leaving it to the FSC or has not gotten them something they feel is fit, has not addressed the issues for them. And of course, the legal recourse is very expensive and long drawn out, which is why I had also raised the question on legal aid. So I hope that at some point, MSF will assess again, a framework for parental alienation. But I have one clarification around the use of the enforcement of access. Will this apply to divorces that have already been approved, and even if it's multiple years, because parents who feel that they have not been given the due access to their children right now, will they be able to now go to court and get their orders for access approved when their kids may say they don't want to see them because they have been conditioned by the other spouse to believe to actually break relationships with the current spouse. Sorry, with the previous spouse. Yes, thank you. I hope that's clear.
I thank the member for her clarification. I think on the last point that she raised, the court will have to consider what is in the best interest of the child. They will have to take into account the full facts of the case. I understand where the member is coming from, but the starting point from the court has to be that it is in the best interest of the child. So we hope that now with the current updates to how access is provided, that this would ensure more expeditious redress to parents who face issues with access. Thank you.
Ms. Carrie Tan.
Just to clarify, it will apply to divorces granted in the past and not just divorces going forward.
Yes,
Okay,
that's correct.
thank you.
Ms. Carrie Tan.
Thanks, Speaker. Thanks, MOS, for your address. I'd just like to speak on the point in your response about the maintenance, allowing husbands to seek maintenance, and the response being that currently that is a very small number and it's not the norm. In the interest of developing and uplifting women, I would like to seek the Ministry's consideration that in order to create a mainstreaming, we must start with the right signals. And perhaps to encourage more men to take an equal role domestically, we may need this legislatory safeguard to then nudge different behaviors. And I really think that this would really aid the cause for women to be unburdened from an overproportion of care responsibilities, and to encourage men to take up more of a role in the home as a participating father and spouse. So would the MOS like to comment on whether we can expedite the consideration of this so that we can expedite the accelerating of a different future in mainstreaming men's equal roles domestically. Thank you.
I thank the member for her clarification. There are many ongoing efforts, and they are non-legislative efforts to encourage the mainstreaming of roles of the father, roles of the mother, like what the member has suggested. For instance, the Ministry of Education in its CCE curriculum talks about the roles that different family members play, and they encourage children, students, not to have stereotyped views on what a father's role should be or what a mother's role should be. So I would encourage the member to look at these efforts holistically, and that important lessons and initiatives also have to start very young when it comes to framing the views that society has towards what the roles of fathers and mothers should be. So I would encourage the member to look beyond legislative amendments. Thank you.
Question is that the bill be now read a second time. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Women's Charter Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 44 stand part of the bill. As many as of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Social and Family Development.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Women's Charter Amendment Bill.